Back live with you tonight, John in Focus, and thanks for staying on. Now, some opposition parties are warning that they may legally challenge the Electoral MattersAmendment Bill. They claim that the proposed law, which was passed in the National Assembly yesterday, will lead to a funding formula which favours the ANC. Meanwhile, the governing party insists that the bill is constitutionally sound. Let's speak now to some of those leaders. Build One South Africa leader Mmusi Maimane joining me in the studio. Also in the conversation, IFP's Narend Singh. They voted against the bill. The DA's Adrian Roos voted against the bill. We'll be joined also by Advocate Khumalo, Legal Services for the Department of Home Affairs, on that conversation as well. You can weigh in tonight, 072-110-5584. Drop us an X at Newzroom 405. Gentlemen, good evening. Good to have you. And thank you very much for coming on this evening. Mmusi, let me begin with you, because this was meant really to be an amendment that includes independent candidates to come on board, and you've been rallying a lot of them to come in and be around you there. Where did it become an issue about money and party funding?
No, I think we must take a step back firstly to say, when the initial bill was drafted, we wanted to make sure fairness was on the principle. We wanted to make sure accountability was on the principle. What happened was, as it arrived in the corridors of Parliament, it became a bill that worked for the parties that are within Parliament. And now you are adjusting and making amendments so as to include, but the system is already broken. In other words, I think we should have done better to ensure there's a constituency-based system. I think we should have done better to ensure that actually when we think about democracy, we apply the fairness issue. And then ultimately, when it comes to this question of funding, it was always going to be a challenge, because funding is often an indicator of maintaining status quo. So for many South Africans, they should be concerned that the ANC now suddenly, as the new formula that has been proposed, can benefit more than any other party on the table, because it establishes that elections in this country, because of a lack of constituency-based, end up becoming these national projects. They become instances where ultimately the party who has the gold actually ends up being the one who rules.
Yeah.
And so to me, I think that there's a cause to be made to say we need to reform the entire Electoral Act. We need to reform how we vote, so that we can make sure ultimately citizens have got a better input into that, rather than money being the determinant.
So let me understand, you're saying this is patchwork, essentially. Correct. You wanted the whole lot revamped. But if you were not going to get the whole lot revamped at this particular time, because of course you went to the courts and it didn't work out that way, what are the things that you would have wanted to see that are currently not in this?
I think the first and the biggest win should have been a constituency-based model. Because at this point in time, even the inclusion of independents, as is now being put on the third ballot, that constituency of the independent is still a province, which means that actually somebody who lives in Randburg now also has to convince people in the Vaal, convince people in all far-flung corners of the province of Gauteng, and Gauteng is very small. You can imagine that what happens in the Northern Cape, in the Eastern Cape, etc. So those are some of the issues that mean that in the absence of that, it means the ballot becomes long, it means that your requirement for signatures becomes increased, it means that actually at the end of the day, the funding mechanism, the threshold becomes higher. Whereas if I have to fight an election in a small constituency to explain to the people of a small community like Randburg where their water is, where their schools are, where all of that, the funding demand is less. And therefore I just fear that ultimately, as we're doing this patchwork, we should have started with the first principle, which is that direct accountability, so that politicians fear voters, not the other way around. We should have stuck to that principle, and it was lazy, and I think that we're starting to see the fruit of it unravel continuously.
Mr. Singh, let's bring you in here. Why you as the IFP voted against this? Is it just purely the issue of the political funding that would be... will lack transparency, let me put it that way, and lack thresholds, or is there more to this that would have made you not to support the bill?
Well, firstly, good evening to Tavo and my fellow colleagues and your viewers. I think, as Mmusi says, there are two issues here. But the one is water under the bridge in terms of the construct of the electoral system in South Africa. We as the IFP objected to the construct that was proposed in Parliament on the basis that we proposed that there should be constituencies. Even if we started with 50 constituencies in South Africa, it would have been a good start. We supported the work of a very high-powered commission that made recommendations to the Minister of Home Affairs, recommendations which he totally ignored and then went ahead with his recommendations. But that is now water under the bridge in terms of the system. But we believe that moving forward, there certainly has to be a total overhaul of the system, the electoral system that we have in place. Now, these amendments that have been brought in these electoral amendment bills are consequential amendments after the Constitutional Court had found that independents have a right to contest elections. But we find that the ruling party has conveniently dealt with amendments which are not going to affect the campaign as such, not going to affect the existence of independence and how the election is run, but affects the funding of political parties, which is something that's enshrined in Section 236 of the Constitution. And this is where we have a problem, amongst other things, that the ANC is now conveniently doing this so that they can get more funding from the fiscus to contest elections, while smaller parties will pay the brunt of not having that funding. And Taba, I was part of the ad hoc committee on the Political Party Funding Act. It was the first time that we came up with such legislation, and that was also as a result of a Constitutional Court injunction that was started by my vote counts, and we came to quite a reasonable settlement there, with the ANC also agreeing that there has to be a proportional and equitable distribution of the funds. And we decided on a particular percentage, 2/3, 1/3, but suddenly now the ANC brings a 90%, 10% formula into the game. And this is something we object to. We believe it's unconstitutional, and it's something that the ANC should not have done in the amendments that they have proposed to us.
Yeah. What would you say if you're a smaller party, generally, of course, you would object to the allocation because you don't stand to benefit, but the bigger your organization becomes, you stand to benefit from that 90%, 10% distribution.
Correct. At the moment, two parties would benefit if this bill is passed, signed into law, and it would be the ANC and the DA. All other parties would lose out, because if we take an amount of, let's say, 500 million that's going to be allocated for political party funding, we are suggesting that we stick to the formula of top slicing 1/3 of the amount, which would be about 160 million, and divide that equally amongst the parties that are currently present in the national legislature. What the ANC is proposing now, that you only take 50 million and divide it equally, and you do the rest proportionally. And we are saying that is unfair. It's unconstitutional, and we certainly would take this matter further to get even the Constitutional Court to give us a declaratory order on the definition of equitable and proportional. Because yesterday, quite conveniently in the debate, the minister spent time talking about proportional, but he forgot that the word equitable is also in the Constitution. So I think there are many options that are available to us, but I suppose I can discuss that a little later after my colleagues.
Adrian, let's bring you in here. Why would a seemingly arrangement that could certainly benefit the Democratic Alliance in terms of that allocation split certainly be objectionable for you?
Yeah, thanks, Thabo, and greeting to your viewers. Thabo, I think we're a party of principles, and one of our key principles is fairness. So, as has been indicated, it's correct. The ANC stands to gain 24.3%. approximately, and the DA stands to gain 9.6%, and every other party loses funding. So if you were an independent candidate coming in, you would get less than half the allocation that you would have beforehand. And so this is clearly totally unfair. The DA believes that the Political Party Funding Act as a whole needs to be reviewed. There needs to be a review of what has happened. Has there been less political party funding as a result of this? And any changes to formulas, etc., it needs to be based on some sort of a policy that is based on reality and facts that we get from determining what has happened and how has it affected political parties. And so certainly the Democratic Alliance, from a funding point of view, we've adjusted to the changes, and we were obviously a part of that as well and agreed to it. But what is happening here is you have basically the ANC putting more than 50 million rand extra into their pockets over the coming financial year, and indeed making 2 allocations to this fund and then holding it back until this legislation is passed. And pretty much every other party in Parliament would lose. So this is clearly unfair, and we need a review of the Political Party Funding Act, its effect on party funding, and whether it has actually achieved what it was supposed to achieve.
And one of the other issues then that are being raised, particularly by the independents, that this should have been an overhaul kind of change, and particularly constituency-based focus as a point of departure.
So the Democratic Alliance in 2013, we submitted a private members bill by James Self, and that's for a constituency-based system. So the Democratic Alliance has always supported that, and in fact, even with the Electoral Amendment Bill, which led to this constitutional amendments, we were the ones that were pushing for a sunset clause to say we need full electoral reform, and that includes discussions about constituency systems and the pros and cons about it. So the Democratic Alliance has put a private members bill in. Sometime that was shot down, and we also mustn't forget the second Laws Amendment Bill that was also before the committee, known as the People's Bill, and that was mysteriously withdrawn, and that included a constituency system as well, which the DA was open to exploring. So I think it's certainly something, the compromise at the end, we said there should be a sunset clause. We have the Electoral Amendment Bill to facilitate independents participating in national and provincial elections. But we need a proper process, and this is where the Electoral Reform Panel has now come into that legislation to undertake that reassessment of our voting system and how we go forward.
Yeah. We are expecting Head of Legal Services at the Department of Home Affairs to join us. In fact, he has been struggling to join into the conversation. That's Advocate Kumalo. And as soon as we've established a more stable connection to him, certainly we'll bring him into this conversation. Let's talk a little bit about that private members bill, Mmusi, Maimane, and the consideration that would have been in that private members bill.
Yeah, absolutely. And we worked with the Congress of the People at the time to advocate for that bill coming from the Constitutional Court. And I think 2 things had emerged. Even the panel report that was led by, Mr. Vali, indicated the fact that the choice needed to be made is a minimalist approach or a 200-200. If we had a 200-200 split, which meant that members of parliament were located in communities, that we would have better accountability now. We are suffering, still reeling from state capture. And what is now starting to happen is that instead we are having a form of democracy, but it's party capture, as led by the ANC. So now we've got to actually do the hard yards to go back to that approach. When the president signed the initial bill into law, he was given the task to say an independent panel must be set up to be able to deal with some of these issues within 4 months of the bill. Members of those are known so that we can begin this conversation of the Electoral Amendment Bill. Otherwise, we're going to keep making patchwork after patchwork, and citizens are the ones who are losing out here.
Yeah.
Lastly, if we have to be deliberate about how we deal with this matter of funding, because if we don't, we are opening the door for further capture of parties, but more than anything, it means you and I, the South African public, fund what already sits in Parliament. And even when parties like us, new parties, go out and speak to people to fund, they talk about this multi-party democracy fund that they contribute to. And that applies a similar formula to this issue, which means that you end up with new ideas being left out and old ideas being left in Parliament.
But you're a new party, and you probably need more funds than they do to run. And an amendment that allows you more people to give you more funds would be something that you should welcome.
But
as opposed to that,
do that.
15 billion or 15 million threshold?
This doesn't do that. And I think more than anything, of course, you've got to think hard about how do you enhance democracy. It's a historical issue that comes even, President Mandela understood that, President Motlanthe instituted a high-level panel report. It's cited in there. The Van Zyl-Slabbert report, and there are many other reports that have come. This is only the recent one. So this is not just a new issue. It's an age-old issue. But as Ndate Narend Singh says, we're clear that there are some issues now that we've conceded that we have to go back into the courts to fight for. But if we do not change this and implement that panel that was put into place, I promise you are going to have corrupt funding that eventually occurs, because parties in parliament are well funded through Democracy Fund and parties outside are not. You could make it that problem. And furthermore, you are going to end up in a scenario where actually the rules are not fair for everybody. Yeah. And therefore, it applies to the principle of the free and fairness of elections. All I want is leaders who are accountable to make sure that actually you as the voter are best served by people you can look at, hold accountable, and speak to on a day-to-day basis. That's all I'm asking for.
Right, back live with you here on In Focus, and the conversation continues. Some opposition parties are warning that they may legally challenge the Electoral Matters Amendment Bill that has now been passed through the National Assembly. So before we'll try and get Advocate Khumalo. Advocate Khumalo, are you still there? We did connect with him moments ago, but I think we've lost him again in that connection. So we'll try and bring him back. But during the break, I was saying to you, how do you bring a local guy who's experienced in local matters at a national level, where you need national competencies and understanding of how, macroeconomics work?
I think the point at the end of the day is that the Constitution allocates certain competencies to every sphere of government. Cities reticulate water, they deal with roads and potholes and all of that, and therefore local governments must deal with that. But at a national level, hospitals, healthcare, policing, schooling are all matters that are put to the national government and the National Assembly, with the provinces having concurrent powers. So I then again practically come back to the issue of going, let's look at Charlotte Maxeke here in Johannesburg. Here's a hospital that burnt down, and a wing of it is dysfunctional. So in all reality, if you had a constituency-based model, you'd have a member of parliament who has to come back to the citizens of Johannesburg to explain to them why a hospital isn't working, why a school isn't working, why a police station is dysfunctional. But because you don't have any of that, what eventually happens in parliament is that we vote on all of these budgets and we do all of that. But the reality of it is that when it comes to practical implementation on the ground, public representation isn't facing up to the citizen to explain why you don't have a school, why you don't feel safe, etc. So my call isn't that you just take local people and make them national. My call is that members of parliament need to know they are accountable to people. And it's true of a system internationally. It shows the fact that ultimately if you have surged, already parliament has what is called constituency period, which gives you days where you've got to be in a constituency. What eventually happens is it becomes party work, not public work.
Now that we've got you, let's quickly bring you into this conversation before we lose you again. The parties are saying, one, the constituency-based approach is left out of this amendment bill, but two, there is a sneaking in of the taking out of thresholds, for example, in terms of donations that you can accept, but also donations that you can declare. They're saying this, of course, is to favor the African National Congress. Also, they're saying the allocation split or the distribution of the Democracy Fund based on proportional representation actually favors the bigger parties more than it does the smaller parties. What's your take on that?
Thank you so much, Sam. And I must then clarify that I am speaking on behalf of the Department of Home Affairs.
Indeed.
Yes. So let me start with the issue of the disclosures. Your upper limit as it stands in the current legislation is 15 million. And so that amount then becomes static. So all that has been done through this bill is to say that the upper limit will be determined by the president acting on the resolution of the National Assembly. In other words, the political parties themselves will meet as they are in the National Assembly, and they will make a resolution, and the president will then have to determine the upper limit based on that resolution. And there are safeguards that have been put in place in terms of that bill, the things that the president needs to take into account in determining the upper limit. So the limits have not been removed. It's just that the methodology now is that there will be a National Assembly resolution, then the president will make that determination of the upper limit. The same thing with the disclosure limit, which is 100,000. Now, what we have done in the bill is that there will be a National Assembly resolution, then the president, based on that, will determine the disclosure limit. When it comes to the issue of the split, the proposal that we have made in the bill of 90-10 split, it was influenced by Section 236 of the Constitution, and it's not a long section. It says that to enhance multi-party democracy, national legislation must provide for the funding of the political parties participating in the national and provincial legislatures on an equitable and proportional basis. Now, during the discussions in the Portfolio Committee, the Minister of Home Affairs went into details in terms of doing the calculations in terms of why the 2/3 and 1/3 split would actually not fit the constitutional requirement of equitable and proportional. In fact, from those calculations, it was becoming clear that independents would actually be better off than political parties when you use the 2/3, 1/3 split. So that was discussed in the Portfolio Committee. There were many submissions that were made and there were responses. And the committee was convinced, of course, eventually that the 90-10 split was more close to equitable and proportional than the 2/3, 1/3 split, which was actually giving even worse results. So that is how the department had actually put the bill in place through the committee, and those are the responses. And in terms of the issues of the electoral system, I think Mr. Maimane has actually, I think it was Mr. Maimane that commented on that, but also the colleague from DA, that there is a panel that was established by the 2023 Amendment Act that will look holistically at the issue of what kind of an electoral system is suitable for our country. It is not work that could have been done during this phase where we are merely doing consequential amendments, so it would have been difficult to use this bill to determine the electoral system of the country, even to introduce one option over the other, whether it is constituency based or not. So I think that work is best left to that electoral reform panel. Thank you so much, sir.
So you would say then what you have put in as far as the upper limits and the disclosure limits, the place of a panel in that instance would be taken by the fact that this resolution would need to come from a National Assembly, which would include all the political parties.
Certainly, sir. All that we have done really is to make sure that the president will not be acting on his own or on her own. There will be a National Assembly resolution regarding the determination of the upper or disclosure limit, and then the president will make the regulations or the determination based on that. And I've spoken about the fact that in the bill there are safeguards, so it's not like a blank check. So in determining such a limit, the president will have to take into account, amongst others, the actual fiscal contribution to the public funding for political parties. He has to take into account the inflation. He has to take into account the actual cost of running a party and running elections as submitted by the parties. And so we are saying that as a department, political parties are best suited in knowing what does it cost, what does it take to run a political party. And that's why this proposed amendment is taking into account all those contributions and as factors that after the resolution of the National Assembly, the President will have to take into account all those things that are mentioned there. Thank you.
Back with you here on this road to the 2024 national elections, or general elections as they are put. Opposition parties quite concerned about the legality of the Electoral Matters Amendment Bill. We heard from Legal Services, the Advocate Khumalo, clearing some of those issues. I'll come back to you, Mmusi, in just a moment. But let me go to Narend Singh. Narend, the 1/3, 2/3 split, according to Legal Services, there would have benefited independents more than political parties, one. But two, there seems to be a sense that there are adequate safeguards that are put in place. For example, the National Assembly resolution that would be required, but two, other safeguards like fiscal contributions, like inflation, like the cost of running a party that the President would need to consider in making those decisions on the upper threshold and the disclosure limits.
I'm going to be very brief on this because I know time is against us. And the question I would ask, what's wrong with independents getting more money? They're part of the democratic process. This constitution provides for multi-party democracy. In fact, I empathize with the parties that are not represented in parliament because they're not going to get funding. But let's park the issue of the electoral system. I think we all agree it needs overall. Let's park that for the 7th parliament. But the issue is the question of the funding formula. Why amend the funding formula 70 days before an election when the new parliament can come along and deal with the whole question of funding formula and anything else that needs to be dealt with? The only reason they are interfering with the funding formula is because the ANC wants to get more out of the funds that have been allocated in this financial year. And we are suggesting that we hope good sense prevails, that when this bill goes to the National Council of Provinces, there will be amendments which will bring it back to 2/3, 1/3. That will satisfy all of us, and then it comes back to the National Assembly, we approve it. Secondly, we are ready to petition the President before he signs this legislation and makes it an act, to postpone the implementation of certain sections of the act. For example, the funding formula, until a date in the future that has been done with other pieces of legislation. Or thirdly, we will have to ask the ConCourt for a declarator. What is the meaning of equitable and proportional? We understand what proportional means. What is the meaning of equitable distribution? And I think here this is where the ANC is missing the point, and we feel strongly that the courts will rule in our favor in determining equitable. They may say 50-50.
Yeah.
As being equitable, and then the ANC loses out. We want the elections to carry on date, be free and fair, controlled by the Independent Electoral Commission, and we don't want any hiccups in where the election could be delayed because of court processes.
That's where I was coming to. I mean, in terms of what you're asking for, I mean, are we likely going to get to May 29th and have this not passed, and what would be the impact of that?
Absolutely. So we hope good sense prevails. We want legislation, reasonable legislation to be passed, or, like I said, the implementation of certain sections of the bill to be postponed to a later date. So come June, July next year, when there's a new parliament, a new National Assembly, let them talk about the proportion, whether it should be 50-50, 20-80, or whatever it is, but let them have that opportunity. Now we can see it is just a cash grab. And that's something that we want to avoid, and we want South Africans to know that that is exactly what it is, a cash grab of existing funds that have been allocated by the fiscus via the Department of Home Affairs and the IEC for distribution to political parties.
Right. Adrian, let's bring you in here. It seems the issue that you're raising, the Legal Services says, well, these things have been thought about. There's been a thinking around what does it cost to run a political party, and therefore this is what is being put into this bill. Things like the fiscal contributions that would have been made for that year, the inflation, where it's sitting at that time, the cost of running a party. These are all things that have been properly researched, calculated, and I suppose consulted upon with experts.
So Thabo, the purpose of this bill is consequential. So there was a bill, there was an act to say that independent candidates not participate, and then you have to change certain other acts to facilitate that. And it's got nothing to do with independent candidates. The funding formula, as well as the changes to the upper limits and the declaration thresholds. So I think Advocate Khumalo, perhaps not on purpose, I'm not saying it's on purpose, but perhaps makes it sound like there's no gap. But there will certainly be a gap once this bill is passed, because the regulations that determine what the threshold is, so no more than 15 million that you're allowed to donate, and no more than 100,000 before you must declare the donation. As soon as the bill is passed, those will fall away. And only once the regulations are then updated will the new values come in. So there will be a gap in which time there are no limits. And the Democratic Alliance pointed this out in no uncertain terms and suggested that we simply add in the limits in the interim, which is a very reasonable request that was declined. And you have to ask yourself, you're talking about consequential amendments, which are supposed to be to allow independent candidates to participate and get the kind of airtime, etc., that they are entitled to. And now suddenly you're doing away with the upper limits of declarations, you're doing away with the maximums, and then you're changing the funding formula. So these are all nothing directly to do with independent candidates, and there's another agenda here.
Yeah. Mmusi Maimane, it seems they are saying independent candidates, wait a little bit, wait for the next parliament. We'll have a panel then you can have these conversations around the amendment of the Electoral Act.
I want to say the previous comments are absolutely opposite. This has to do with the ANC finding itself in a funding crunch and wanting to entrench status quo by making sure it gives itself more money. This has got nothing to do with the strengthening of democracy. It moves away from the principle of what does it mean to be equitable as the constitutional provision. And furthermore, here's the challenge. If you write the rules in such a way that they preserve status quo, there are already parties threatening violence that are not represented in Parliament. What then happens when it wasn't a threat of violence, but it's a threat of being able to be funded in ways that are illegal? What happens in ways that those are unregulated as the threshold issue is no longer declared and the questions of transparencies are taken away? You are inventing a situation upon which the conditions of the elections move away from free and fair, enhance participation by parties that actually want to serve democracy, and you put citizens vulnerable. To me, my only interest in this issue is the protection of the interests of the people. Because at the end of the day, once citizens do not know, as the law was put in, and I remember being in Parliament when the first funding proposals came on board, and we made the case to say, now you are creating a state where you can protect what is already in government and be in a way impairing of the opposition. Now worse, you've created a scenario where you are impairing anyone who's outside that system. And I think you are undermining free and fair elections going forward. And you are putting citizens at risk. So to me, I just think that this is a ploy, and it's sinister at the timing. Because it's not, in essence, given that all of us accepted the rules, we've been playing by the rules of declarations, what time it is, what the limit is, why change it suddenly just before an election so crucial as this one, where the ANC knows very well that they are going to lose a majority?
Something that I'm sure, if it continues along this vein, will be tested in our courts. But gentlemen, let me thank you very much for coming on. Mmusi Maimane, Narend Singh, as well as Adrian Roos and Advocate Khumalo.